Hello. Thank you for joining today's presentation of Protecting Your Brand, Trademark 101 for Non-Lawyers. I'd like to begin by thanking 2112 and the Center for Creative Entrepreneurship for hosting today's presentation. The presentation today is a variation on a presentation that I give to my fellow attorneys, but today's presentation is going to be directed to non-lawyers, people who interact with brands and own brands, and let them know what they need to about trademarks, how to obtain them, how to protect them. I invite you to ask questions either before or after the presentation. You can do so by either emailing me or through the chat feature on today's presentation. First, a bit of introduction. I'm a partner at Ziliak Law. Ziliak is a boutique Chicago law firm, which has been around since 2013. We have concentrations in entertainment, media, trademark, copyright, financing, and litigation. I'm the chair of the Entertainment and Media Group, as well as chief member of the Trademark and Copyright Group. Collectively, we have decades of experience protecting brands and creative content. And I personally have 20 years of experience representing clients ranging from individuals and small startups to Fortune 500 companies, both in branding, litigation, and in other areas. So why are we here? The question for many small business owners is, do I need trademark protection? Along with entity formation and employment issues, trademark protection is often one of the very first issues that arise for a small company. So the question I would ask in response is it important to your business that your goods and services are distinguished from those offered by other businesses? In other words, if another entity were to adopt the same trademark or name for its products, would that damage your business? If the answer to either of those questions is yes, then you've come to the right place. Today's presentation is going to focus on the selection, clearance, registration, and enforcement of brands and trademarks. So before we get into those things, let's ask, what is a trademark? In the colloquial sense, a lot of times trademarks get lumped into either other forms of intellectual property, with business names, or with other sort of general concepts. And so it's helpful to identify from a legal perspective what a trademark is. A trademark is a word, a phrase, a symbol, or a design that is used to identify and distinguish the goods and services of one producer from another. It can be for a unique product. It can be those manufactured by yourself, or it can be those that are manufactured by others that you've been given permission by the mark holder to apply the mark to. So even if the consumer doesn't really know the source of the product, if the mark on the product tells them that it comes from one place, that's functioning as a trademark. For example, you may not know who makes Snapple, but you understand that when you buy a Snapple beverage, it's coming from the same source as all other Snapple beverages. Hence, Snapple is functioning as a trademark. So what else does a trademark do? It also assures consumers of the quality of the goods bearing the mark. It lets them understand that when they buy a product, everything that's sold into that product is coming from the same place. So if they enjoy a product and want to buy it again, they can be sure that if they buy a product having that same mark, it's going to have the same qualities as the product that they initially purchased. It also is reflective of the business goodwill and brand identity to allow consumers to associate particular products with particular sources. There's an additional element of consumer protection that goes along with trademarks. From a legal and public policy point of view, it's to the public benefit to allow consumers to have that understanding that when they're buying a product under a particular name, that it's always going to come from the same source. And if someone else is coming along and using that same name in a way that deceives or confuses consumers, then that's something that trademark law is designed to combat. In that way, it's distinct from other branches of intellectual property, such as copyright or patent, which don't have so much of a consumer protection. Instead, those are really designed to encourage and protect other sorts of behavior, which we'll talk about very briefly in a few minutes. A trademark is also an asset of the mark holder. For a lot of companies, the brand identity and the trademark is the most valuable part of the company. If you can imagine, Apple or Harley Davidson, the difference in what they would be able to charge for their products were they not able to use their famous brands attached to them. Those assets over time have become overwhelmingly valuable. Trademarks can also be licensed to others. There are a lot of instances where the original user of a mark will seek to branch off into other related areas of the marketplace and do so through a license of its mark to a third party, under which it will oversee the production and the quality of those goods and services, but they won't actually be providing them itself. And so there's an additional aspect to trademark ownership through licensing, which provide a huge source of additional value for a lot of mark owners. I briefly mentioned other forms of intellectual property, and for the non-lawyer, it's often important to distinguish what they are. Copyrights, for example, protect works of authorship, as opposed to source identifiers or brands. So if you're seeking to protect rights in a book or a movie or a song, those would be the domain of copyright. Patent, on the other hand, protects inventions. If you have an idea or a concept that's both novel and has been reduced to practice, it's potentially patentable. What patents and copyrights have in common is that they're both limited time monopolies that ultimately emanate from the Constitution. It's a trade-off between that monopoly protection and the encouragement that it gives to authors and inventors to invent and to create. Trademarks are a bit different. Trademarks come about for a different reason. They come about to protect consumers and to protect the identity of the source of the product. And unlike copyrights and copyrights and patents, trademarks can be perpetual. There are some trademarks that are over 100 years old. Copyrights and patents, by virtue of the language in the Constitution, are of limited time. Granted, with copyrights, it's a very, very long time. But a trademark can be perpetual so long as it remains in use. Another area of intellectual property are trade secrets. Trade secrets protect confidential formulas, practices, processes, designs, compilations of information. There's some overlap between these different areas of the law. Databases, for example, can be subject to both copyright protection and trade secret protection. If you're talking about a comic book, the contents of the comic book would be protected by copyright law, but the word Marvel would be protected by trademark law. And some logos, if they have enough content to them, could potentially be protectable both under copyright law and trademark law. You really need to analyze the applicability of each of these kinds of protections independently from one another. So let's briefly talk about different kinds of trademarks. I hear I'm using as an example some of the trademarks that are used by Apple. Apple has its house mark, Apple, which would be applied to all of its products across the entire company. And then within Apple, they obviously have their different brands that they apply to different Apple products. And so both of those are functioning as trademarks. Additionally, there's the Apple logo and all of the variations of the Apple logo. If you were to do an owner search on the Trademark Office website, you likely would see that Apple is the owner of dozens, if not hundreds, of different trademark registrations for different variations of its house marks, brands, and logos. Now, for a small company, the house mark and the brand will often be the exact same thing. And that's fine. And that might even stay as the company grows. There's nothing wrong with having that. There's nothing that requires you to have both a house mark and a brand. As companies evolve, they often will diversify and seek to offer different types of products, leading to a whole portfolio of different marks that they would use on their different products. In addition to these examples, you can also have a composite mark, which would include both design elements along with textual elements. And that's a very popular way to construct a trademark as well. And you can also have a stylized mark, which would be something like a house mark or a brand, except used in a very distinctive font. I have here a bottle of Coca-Cola. You can see the stylized Coca-Cola script. That itself is a trademark beyond the mere words Coca-Cola. The company obviously would protect both. It would protect both the Coca-Cola name as one of its brands, and it would protect that stylized version as separate trademarks. So in addition to those different kinds of marks, there are a few related assets that a company can have. For example, a business name can be protected on the state level. A lot of times, a small business owner will think that by registering a business name, such as an LLC designation or a corporation designation, with the Secretary of State, that it's protecting that name as a trademark. That's really not so. That's really a separate process for a separate purpose. The state registration process for an entity certainly does not permit, in most states, the registrant of a business to use the exact same name as one that's already in use. However, it's not a substitute for trademark protection. It doesn't actually give you any rights in court. It doesn't really do anything down the road, except perhaps prevent someone in your state from registering the exact same corporate name. If they were to go ahead and use that name in commerce, there's nothing that the state business name registration would do to prevent that. Oftentimes a business name is used that way, but not necessarily so. You can have a business name and then just use that for your legal documents and so forth, but not actually apply that to your goods or services in a way that is telling the public this is where this product comes from. Similarly, domain names can also function as trademarks under certain circumstances, or at least be given some sort of quasi-trademark protection. If someone were to take your very distinctive mark and register it as a .com and begin offering similar or confusingly similar goods and services on that website, There are different ways that a trademark owner can seek to prohibit that, both through mandatory arbitration and through a provision in the federal trademark statute. So here we have up on the screen some non-traditional marks. In addition to everything we've talked about before in terms of names and logos, there are also different non-traditional marks that can function as trademarks and source identifiers to consumers. Here we have the famous Coca-Cola bottle. The shape of that bottle is actually a registered trademark. Because that shape is so distinctive, and because consumers have come to understand that the shape of that bottle is associated with Coca-Cola, the shape of that bottle can function as a trademark. Similarly, the Weber grill on the right, that product configuration, the shape of the grill with the semi-oval cooking pot, that is a registered trademark of Weber. Now, there are a couple rules for registering and seeking protection for a product configuration. You can't seek trademark protection on functional features. So if you were to have, if Weber were to advertise that the reason its grills work so well were because of the shape of that kettle, that would really prevent them from also seeking trademark protection. They essentially have to establish with either a court or the trademark office that the configuration that they're seeking protection for is non-functional. Additionally, they also need to prove that consumers in the marketplace have come to identify that particular product configuration with a particular source. In other words, with Weber. And over time, Weber was able to do that. Some other interesting sorts of trademarks, decor. If you have a very distinctive restaurant decor, for example, which has come to be identified with a particular restaurant or a particular chain of restaurants, that can be protected as a trademark if the mark owner is able to prove that it's non-functional and people have come to identify it with a particular source. Sensory marks are interesting in that sensory mark can be sound. For example, Intel has the very famous audio progression that is contained within its advertisements that consists of a series of 5 notes, which according to the trademark office are D flat, D flat, G, D flat, and A flat. That's a registered trademark of Intel. Color can also serve as a trademark on its own, even apart from any design or any textual elements. For example, the color brown, as applied to delivery services, is a registered trademark of UPS. Pink is a registered trademark of, I think it's Dow Corning for insulation. And magenta is a registered trademark of T-Mobile for cellular phone service. A few very recent sensory sorts of marks. Scent. In the last few decades, scent has been acknowledged to be a feature that can function as a trademark. One trademark owner was able to register cherry-scented engine lubricant as a trademark. Non-functional, and they were able to establish it in the marketplace. Consumers had come to identify that cherry scent with a particular producer, so they were able to obtain trademark protection for that. Similarly, motion. If you've ever stayed at a Peabody hotel, you may have seen the duck walk with the ducks that walk through the lobby and into the fountains. that activity, that motion, it just is a registered trademark in connection with Peabody's hotel services. So not all trademarks are created equally. More distinctive marks are given a broader source of protection than less distinctive marks. And in the law, there's a spectrum that nearly all US courts use when evaluating the distinctiveness of a trademark, which ranges from the generic on the one end to the fanciful on the other end. And so let's start at the left-hand side, the generic end. A generic name cannot serve as a trademark at all. It just tells the consumer what is the product, what type of product is it. And so, going back to my Coca-Cola example, Coca-Cola is a soft drink. So no one could register soft drink as a trademark. It's a word that just tells the consumer what it is. It doesn't say where it's from. Usually, the biggest kind of conflicts and an area of dispute, both in terms of litigation between two parties and with the trademark office during the registration process, is between these next two categories, descriptive and suggestive. Now, a descriptive mark will describe for the consumer a key feature of what the product is or where it's from. And so here the example is American Airlines. Airlines being a generic term, and American describing the origin of the company. They're an airline that comes from America. And so that would be considered a descriptive mark. A suggestive mark is one that requires a bit of imagination in order to understand what the underlying product is. Here, Burger King, burger, generic, king, that doesn't really tell you kind of anything directly about the product. So when you combine them, you probably have an idea of what the underlying product is, but because king doesn't directly describe any attribute of the restaurant services, then it's deemed a suggestive mark. The distinction between these two categories can be somewhat difficult to make and is often a judgment call, but it does have significant consequences. A suggestive mark is entitled to protection and registration. A descriptive mark is not necessarily, unless you can prove that consumers have come to identify your descriptive mark with a particular source, then it's not registrable or necessarily protectable. And so American Airlines has been able to register its mark and protect its mark as a very famous mark. Only over time, consumers have come to identify that American Airlines is when a flight or when a service is provided under that mark, that it's coming from one place, that it's coming from that company. But the battle between those two categories can have very significant consequences. Moving on to the other two categories, arbitrary marks are English words that are applied to goods and services that really have nothing to do with their English meaning. And so Apple really has nothing to do with computers or electronic devices. So as applied to those particular products, the Apple mark is arbitrary. And then fanciful is exactly what it sounds like. It's an entirely made-up word. Arbitrary and fanciful marks are considered the strongest marks and are given the broadest scope of protection. Now here, I would acknowledge that there's frequently a battle during the conception process between wanting to have a mark that tells consumers what the product is and having a very protectable, strong brand. And it's really a decision between having a mark that brings great value now versus a mark that brings more value in the future. If the priority is to tell consumers what it is, get established in the marketplace immediately, then oftentimes marketing folks will push for more descriptive marks that are going to convey that information in a very succinct way to consumers through the brand name or through the product name. However, as we discussed, there can be difficulty down the road once you seek to register and seek to protect that mark, because it's going to be given a more narrow scope of protection. By using an arbitrary or fanciful mark right from the beginning, you're going to be given a broader scope of protection down the road, even if you have a little more work to do right from the start in order to educate consumers about what the product is, since the brand that you select isn't going to be carrying that weight for you. So let's talk a little bit about the conception and clearance process. When a mark is first conceived, it can come from several possible sources. It can come from the founder of a business. It can come from a marketing department. It can come from a third-party brand consultant. I do think it's important to note that if you're going to use a third party to give you ideas for your branding, to make sure that you get an agreement in writing that all of that is being done for the benefit of the business, and that any names or any rights that come out of that process belong to the business and not to the consultant. A lot of times, the lack of clarity in such arrangements can cause a conflict down the road. So it's important to get that agreement in writing right up front. So once you have narrowed the field to one or maybe a few different names, the next step in the process is to conduct a search. A lot of brand owners, particularly companies just starting out, will do it themselves. But many clients find value in retaining counsel at this point for help with the process. And there are two different kinds of searches that can be performed. The kind of more basic one is a clearance search, where the attorney or the client will conduct a search of the records of the Patent and Trademark Office, often supplemented with internet searches, to see who else is out there using identical or nearly identical marks in this field. And oftentimes, that can be called a knockout search because it will identify marks that are clearly not available. A lot of times, if that comes back clear or maybe a little hazy, the next step, and a lot of larger entities will always do this as a matter of course, it's possible to obtain a full country search, which will search not only the trademark registers, both on the federal and state level, but it will also search for different common law and business usages, other searches on the internet. It'll search for domain names. It'll search for corporate names on different corporate registries. It's a much more robust search, which will give a much clearer landscape for whether the mark is available. And so, once you engage in this process, there are really two things that the attorney is looking for. First, the trademark is not going to be available if the same mark or a confusingly similar mark is federally registered, or if it's the subject of a pending federal registration, assuming that application ultimately achieves registration. So that would be a registered mark that blocks your ability to file for or to use your proposed trademark in commerce. The other thing that could potentially trip you up at this point is the use of a confusingly similar mark in commerce. In other words, even if that prior user has not obtained a federal registration for use of its mark, it could block your use of that if the mark is similar and it's being used in connection with similar goods and services. The other issue that is frequently considered by attorneys in doing these searches is registrability, in the sense of whether the mark may be generic, descriptive, or suggestive. In other words, if you have a mark that kind of rides the line between one of those categories, part of this search and clearance process will be to evaluate similar marks that have been applied for by others in the past, to see how those words are considered by the trademark office, and whether you could run into difficulty in registering the mark given the level of distinctiveness that you see. So I mentioned in here, in this slide here, that you need to worry about both prior registrations and by prior use. It's important to note that the basis of trademark rights in the United States is use. In other countries, in fact, in most countries around the world, trademark rights are obtained by filing an application. That's not true here in the United States. Here in the US, if you file an application, but you never actually use the mark that's the subject of the application, or if the application never proceeds to registration, that application or registration doesn't convey in and of itself any rights. It's really use in commerce that gives the trademark holder rights and the ability to protect its mark from use by others. So the date that will apply to priority will be one of two things. It will be either the date that the mark holder first began to use the mark in commerce, and that's typically the priority date that will apply. Or second, it could be the date that's obtained through the filing of an intent to use application. Now, a couple seconds ago, I just said the filing of the application doesn't necessarily grant you any rights. This is the exception to that rule. If you file an intent to use application and that application ultimately proceeds to registration, your priority date will actually date backward to the date that you filed that application. In order to maintain your trademark rights, the mark owner needs to continue to use the mark in commerce. If that use stops for a significant period of time without a good reason, then the mark may be deemed abandoned, and the trademark rights will go away. Oftentimes with famous brands that are no longer in wide circulation, whoever owns title to that mark may still make very limited use of that mark simply for the purpose of maintaining trademark rights. Because if they don't, then that potentially valuable asset, which could theoretically make a comeback, would go away. So some sort of continued commercial use is necessary in order to retain trademark rights. Additionally, use must be proper. And we'll show you in just a couple minutes some examples of what can happen when proper use isn't maintained over time. And then the last thing is a trademark owner needs to stay diligent about challenging improper and unauthorized use by third parties. If you have a protectable trademark, but others are running rampant in the marketplace using that same mark on highly similar products, that can really damage that mark's ability to tell consumers where those products are coming from. And so if a mark holder doesn't challenge and do something about those infringers, those rights in the mark can dissipate. So let's talk a little bit about rights that you have without obtaining a trademark registration. For a lot of small businesses, they'll have started their business and have begun offering goods and services to consumers, but will not have necessarily filed an application for federal registration of their mark. Nevertheless, they still do have trademark rights. Those are called common law trademark rights. Those rights come from the laws of all 50 states. They are somewhat limited. They're limited to the geographic area in which the product or service is marketed. So, for example, if I have a restaurant here in Chicago, my rights in the name of my restaurant, assuming it's sufficiently distinctive, could be limited to not just the Midwest, not just to Illinois. They could even be limited to just my neighborhood if the only market for my restaurant is just my neighborhood. So depending on the scope of the geographic area in which the product is being offered, the common law rights can either be very limited or they can be somewhat expansive in geographic scope under certain circumstances. As noted, common law rights, like all trademark rights in the US, come about through use of the mark in commerce. So those rights are only going to start to be generated after the product is actually available for purchase by consumers. And it's important to note that the owner of a common law trademark can have their rights either limited or curtailed entirely if someone else has begun commercial sales first or has filed an application first. So using my Chicago restaurant example, if I begin using my mark in August of 2020, but someone filed an intent to use application with the US Trademark Office in July of 2020, even if they don't begin to actually use the mark until December, they would still have prior rights by virtue of their intent to use application. If I beat them in terms of use, if I begin using my mark prior to their application, I could be safe in Chicago, but I could be limited by virtue of their federal registration to only the geographic region where I was operating when they filed their trademark, when they filed their federal trademark application. These issues of common law versus federal trademark rights can be very tricky, and ones that, number one, I would recommend talking with counsel about if it ever comes up, but also can be alleviated by filing a federal trademark application. One fundamental principle of trademark law, which merits at least a brief mention here, is that trademark rights are always defined by the goods and services on which the mark is used. The rights are not in the name on all imaginable products. the question is whether consumers would expect other products that you sell that are sold under your trademark to be offered by you. So in other words, if one company offers natural gas extraction equipment under the trademark Smush, would that cause a likelihood of confusion with a nail salon that offered its services under the trademark Smush? Almost certainly not. It's the same mark, same word, but no one expects industrial equipment to come from the same source as a beauty salon. However, if a company opened up across the street from the nail salon offering hair salon services under the same mark, that probably would lead to a likelihood of confusion because consumers could easily think that the operators of a nail salon were also operators of a hair salon. So you really need to look at the similarity not only between the marks, but also between the underlying goods and services. And you see this principle with some famous marks that are used by multiple companies. For example, Apple Computers and Apple Records coexisted for many years, Delta Airlines and Delta Faucets. So long as those markets stay distinct and consumers don't see a likelihood that one would be offering products in the other's area, then there's no infringement, there's no likelihood of confusion. So let's talk a little bit about the registration process, about the process and about the benefits. The flow chart here, and I won't go into it in tremendous detail, but the chart here generally shows the path that a trademark application takes. And so a simplified version of this is that first, an application is prepared and filed, which states the applicant, the mark that the applicant is seeking to register, what the goods and services are that the applicant is seeking registration for, along with various other information that the trademark office will require in order to assess the registrability of the mark. At that point, the trademark office will examine the application to determine whether it's eligible for registration or not. If it passes that examination phase, then it will be approved for publication. If not, there's a process called an office action through which a trademark examiner will issue a refusal, and that refusal can be based on kind of technical issues that need to be resolved, which can be usually resolved with a phone call or some other minor action, or it can be more substantive. For example, we talked before about the difference between a descriptive and a suggestive mark. If the examiner determines that the mark is too descriptive to function as a trademark, there could be a refusal issued on that basis. Similarly, if the examiner finds that the trademark is likely to cause confusion with a prior mark on the register, a refusal can issue based on a likelihood of confusion with that prior application or registration. If that happens, then the applicant, or more commonly the applicant's attorney, will need to file a response to that office action to seek to persuade the examiner that they were wrong in issuing the refusal, and that the mark should in fact be registered. And that can be resolved in that fashion. Sometimes it can't be, in which a final refusal is issued, and then the applicant needs to make a determination as to whether to appeal or not appeal. But if that process goes well, then the mark is published for opposition. When a mark is published for opposition, it goes into what's called the Official Gazette, a publication of the Trademark Office, and then anyone in the world who thinks they would be damaged by the trademark registration has a 30-day period to potentially file a notice of opposition to the application. Usually that doesn't happen, but sometimes it does. If it does, then there's a whole separate process through which the parties fight it out. But if no one files a notice of opposition, then the mark will proceed either to registration if you've provided proof of use in your initial application, or a notice of allowance if it's an intent to use application. If you've provided use, then you'll get your certificate of registration and the process is complete. If you have a notice of allowance, you then have a period of time to file your proof of use, either within 6 months, or there are extension periods available as well. But those extension periods are limited. I think it's a total of 5 extensions you're allowed, so about 3 years. So what are the benefits of a federal registration? So to begin with, there are certain defensive benefits. We've talked a bit about how oftentimes brand owners will begin with a trademark search. If you have registered your mark is going to come up on a search that others do, and provide notice that, hey, I have a trademark registration, don't adopt this mark, or else you'll be infringing on my rights. Similarly, we talked about how the trademark office can refuse registration based on a prior registration of a third party. And so that third party can be you. If you're registered, your mark can be cited against future applications from third parties seeking to register a similar mark for similar goods and services. There are also litigation advantages that having a registered trademark give that are superior to a mark owner that only has common law rights. For example, there's a presumption that your mark is valid. There's a presumption that you own it. There's a presumption that you have the exclusive right to use it. And it also prohibits the good faith adoption defense, which may be available if you only have common law rights. No one can come into court as a defendant and say, oh, we adopted our mark in good faith. We had no idea that this mark was out there. If you have a registered mark, everyone is presumed to know about it. Additionally, if you have a U.S. trademark registration, that's going to provide you protection throughout the United States, beyond whatever geographic area you're currently operating in. And so that's going to give you protection into markets that you may wish to expand into in the future. There are also international implications. By obtaining a U.S. registration, you can also leverage that registration to get earlier priority in foreign countries if you seek to expand internationally. Finally, having a trademark registration makes available to you statutory damages, which can be a great avenue toward obtaining a monetary remedy in an infringement action, particularly if your damages might otherwise be hard to calculate. And so, I think one area that I briefly touched on earlier is proper use of trademarks. A trademark should always be used as an adjective. It should not be used as a noun. So, for example, when you're talking about, Levi's jeans, if you were, working for Levi's, whenever you made your ad copy or talking about your company's product, you'd always talk about them as Levi's jeans, not as Levi's as a noun. Similarly, you would call it an Intel processor or refer to Warner Chappell Music Publishing. Always use the mark as an adjective in front of a generic word. In terms of presentation, you should always use either the symbol TM or the symbol R in a circle where appropriate. TM can be used in connection with any trademark that the mark owner is claiming trademark rights in. So a mark that's just subject to an application, one that it just has a common law rights attached to it. R in a circle should only be used in connection with a registered mark. So R in a circle is the more robust, more meaningful designation. But wherever you're using your trademark, you should always use one or the other symbol to designate to the public that you consider that designation to be a brand of the company. In using the mark in text, we'd also recommend using some sort of designation to distinguish the mark from the surrounding text, whether that's using the mark in all bold or in a distinctive font or color, all capital letters, quotation marks, whatever you need to do in order to designate that as a trademark. What you don't want to do is to just use it with a lowercase initial letter, just like any other word, because that's not kind of serving to identify that particular word as a trademark and as a brand. So why is proper use important? If consumers come to identify your mark with a product or a service rather than with a particular source, then the risk becomes that the mark becomes the generic word. And this list here shows a list of different products that all started out their lives as brands. And over time, because of the way consumers came to identify them, and perhaps because of misuse by their owners, they ultimately became generic words. And when that happens, the owner of those marks loses trademark rights. So let's talk for a few minutes about unauthorized use. Once you have trademark rights, whether they be common law or whether they be through a federal registration, what then? It's important that a trademark owner constantly be vigilant about the use of that mark or about confusingly similar marks by third parties. How do you do that? By from time to time staying abreast of what else is out there. That can mean running a trademark search on the US Trademark Office website. It can mean looking around for domain names that include your mark to make sure that no one's operating a website with that trademark in the domain name, particularly if that website is going to be offering competing services or products. And also, staying abreast of the marketplace. If you're at a convention or a trade show and you see one of your competitors has adopted a mark that's confusingly similar to one of yours, it's important that action be taken. And so what does that mean to take action? Typically, certainly it means getting an attorney involved. And what the attorney will likely do after assessing whether this is a matter worth going after is probably to start with a demand letter. If it's an issue that can be resolved by agreement between the parties, then that is typically the less expensive route to solving the issue. And if that's not possible, then litigation often is the next option. Litigation in the trademark area is typically done in federal court, although not always. When a registered U.S. mark is at issue, then either party will have the right to bring the action into federal court. Some other areas where trademarks are often enforced. Once you have a registered trademark, that trademark can be recorded with U.S. Customs, and the mark owner can work with U.S. Customs to stop infringing products at the border. Similarly, there are processes when a trademark is used in a domain name or on social media in an improper manner, especially where some sort of connection or affiliation is being suggested or implied with the brand owner by this infringer. There are processes through which those posts or can be removed, or those domain names can be transferred. So just to summarize, what we talked about before in terms of risks to trademark rights. You want to make sure that you're not using the mark as a generic word. You want to make sure you police the mark. You also want to make sure that your licensing follows all of the rules of trademark law. That's a bit beyond the scope of our discussion today, but a trademark lawyer can help guide you through that process and make sure that there's nothing that trips you up in the licensing process that jeopardizes your trademark rights. Finally, just a few words about proving infringement. If worse comes to worse and someone is infringing your mark and you need to sue them in court, to prove. Very briefly, a plaintiff in a trademark case needs to prove that they own the mark that they're asserting in the litigation, and that what the defendant is doing is causing a likelihood of confusion among consumers. Now, what does likelihood of confusion mean? Each different circuit in the United States, each different kind of department of federal courts, regional department, has somewhat different factors that they apply. But what it really all comes down to is how similar are the marks, how similar are the goods and services that the two parties are providing, how similar are the channels of trade. In other words, how are the products sold? Are these sold in the same department at Walmart? Are they marketed at the same trade shows? Are they marketed to the same sorts of consumers? The strength of the marks, we talked about descriptive versus suggestive versus arbitrary versus fanciful. How famous are the marks? And is there actual confusion in the marketplace? Have consumers been returning the products of one company to the location of the other? Have there been phone calls or emails that reflect confusion between what the source of the products are? These are all factors that a court is going to consider in evaluating whether there's a likelihood of confusion or not. Finally, if you win, the remedies that are available to you are injunctive relief, which means a court order that the defendant needs to stop the infringing conduct. There can be monetary damages that are available, either the lost profits of the plaintiff or the ill-gotten profits of the defendant. The court can also order forfeiture or destruction of the infringing goods, the pirated goods. And finally, in exceptional cases, the court can order the payment of the plaintiff's attorney's fees and costs. That is my presentation. I'd like to thank you all for joining. If you have any questions, the last slide here is going to have my contact information. I'm happy to answer any questions about my presentation that you have, and if you need help on any of these issues, I would be happy to discuss them with you. Thanks again for joining, and we'll see you next time.